me give him a call. Share. Okay. Okay, everybody, welcome to the meeting. I'd like to call it to order. This is the meeting of the Texas Therapy Advisory Board, and it is now 1 o'clock. So I'd like to welcome all of you who are with TDLR on the board, as well as all of you who are viewing the video of this meeting. Welcome. And I'd like everybody to mute your microphones, only turn them on when you speak, and please to announce your names when you're speaking. Thanks so much. So Anna, will you do the roll call, please?
Yes, sir. Russell Rust,
Present.
Susan Sparks is absent. Caroline Guerin,
Present.
Carol Willis,
Present.
Antonio Gracia Jr.,
Present.
Kitra Taylor,
Present.
and new board member Callie Morris.
Present.
Presiding officer David Lauderstein.
Present, thank you.
We have a quorum, sir.
Okay. Let me ask Callie Morris, who is the newest person just appointed to the board, to say a little bit about yourself. Welcome.
Thank you. I've been in the industry for about 15 years as an operations manager in the massage and spa arena. And so I've also served on several boards for school boards over my time. But this, of course, is my biggest honor. And I'm just grateful to be here and hope I'm able to contribute to this committee. over my term.
Very good. Welcome to you.
Thank you.
Mhm. Okay. Mary Winston, I believe you have a recognition of someone important to massage in Texas?
I do, I do. Unfortunately, we were not able to get him to attend virtually. I wish we could have, but we will continue to reach out. How many of you can say that they've been to the Olympics once, much
Mm,
less 5 times?
mm,
Mr. Benny Vaughn, that's who. Today, we're taking our time in this meeting just to honor TDLR's double licensee, Mr. Benny Vaughn. Mr. Vaughn is the owner of Benny Vaughn Athletic Therapy Center in Fort Worth and has been a licensed massage therapist since 1975.
mm.
He also has held an athletic trainer license since 1985. Mr. Vaughn provided services to the USA track and field team at the 1996 Olympic Games in Atlanta as the medical liaison and as part of the medical and performance preparation staff at the Olympic Games in Athens, Beijing, and London. In the 2021 Olympic Games in Tokyo, he was selected by the United States Olympic and Paralympic Committee medical staff to serve on the Tokyo sports medical team as a senior hands-on soft tissue therapist. Mr. Vaughn received the National Meritorious Award from the American Massage Therapy Association in 1989, the International Achievement Award from the Florida State Massage Therapy Association in 1996, and an Award of Excellence from the National Athletic Trainers Association in 1999 for his educational video, Massage for Sports Health Care. In 2000, Massage Magazine, an international publication, named Mr. Benny Vaughn as one of the 50 most influential professionals of hands-on soft tissue therapy in the world over the past 100 years. That's outstanding.
Mhm.
In 2012, Mr. Vaughn received the One Concept Lifetime Achievement Award for his contributions to the massage therapy profession. As his extensive experience reflects, Mr. Vaughn has traveled the world providing massage therapy and athletic training services to athletes representing the United States for many years. Thank you, Mr. Benny Vaughn. Today, we just wanted to take this moment to acknowledge you for the contributions that you've made to the massage therapy and athletic training professions and for representing Texas not only throughout the nation, but also throughout the world. Again, thank you.
Great. Russell, Ross, do you have anything you'd like to add? I know you've known Benny quite a while too.
Um, Hold on.
Oh, you're muted now. Muted.
Am I muted now?
No, you're good now.
Okay. Anyway, I've never got to work with him personally, but he did take 4 of my graduates under his wing, and he took them to Greece with him, which was
Mm.
very exciting for me, even though I did not get to participate. To have therapists that represented my school, my education, being selected to go to Greece was something else. I will say they did not get to work on the athletes of his caliber. They worked in the village. They did say they ate a lot of bologna sandwiches. So for all those seeking great sports therapy or getting in that business, remember you got to pay your dues first. So just don't give up. Keep volunteering. Eat the bologna sandwiches, and someday you can ascend to what Benny Vaughn has accomplished. Thank you.
Yeah. I just also want to add our appreciation for Benny. I've known him, I realize, since 1982, long time. And I know that he is one of the main people responsible for the uprising of sports massage throughout the US and the world. Him and Bob King and some other people, really, all of them brought sports massage above the horizon. And we're very grateful to Benny. He did a beautiful job with lots of videos that he sent from Japan. And just congratulations, Benny, and thank you very much. And thank you, Mary and Russell, and all who've been supportive of massage in Texas including Mr. Benivon. Cool. So now we move on to a training for board members. And I'd like to call on Molly Fudel, who is the Assistant General Counsel. Molly, it's all yours.
Mr. Lauterstein, it's actually going to be me, Elizabeth Salinas Strittmatter. I'm also an Assistant General Counsel on the
Oh, that's right.
program.
Yes, I'm sorry. Go ahead.
That's okay.
Yeah.
And so Anna is going to be running slides for me. And let's go. Today, we're going to be talking about 3 specific things that y'all need to be aware of: the Open Meetings Act, the Administrative Procedure Act, and the Public Information Act. And we're going to start with the nuts and bolts of the Open Meetings Act. So as some of you may know, or perhaps all of you know, that the Texas Open Meetings Act specifically is designed to make sure that our government operates transparently and openly, and that the public always has a window into government actions. So the act at its core requires meetings of governmental bodies, including this one, to be open to the public and to be preceded by public notice of the time, place, and subject matter of the meeting. These provisions are mandatory, and so that is why you will see us putting out that agenda, which we'll talk about in a little bit, because the agenda puts forth all of the things that the public is being noticed on of what's going to be talked about during any given meeting. So one of the other key concepts here of the open meetings, you heard Anna reference at the top. She told Chair Lauterstein, we have a quorum. And that's very important because a quorum is needed of the majority of members of the board in order for you all to take any official action. Now, if you have less than a quorum, you could meet, but you cannot take any official action. So it's always important for us to note during the meetings that a quorum is present so that the public is on notice that the board can take official actions during the course of the meeting, and that this meeting is not limited to discussions, just simply discussions. Now, of course, you know what happens during these meetings is that we talk about an issue or an item, and during the meetings, the board, any members of the board, are allowed to engage in deliberation. But the deliberation under the Open Meetings Act does have to concern public business or public policy over which that particular governmental body has supervision or control, or anytime the body takes formal action. So because you're the massage therapy board, your meetings are necessarily limited to any actions that are under your purview as the governmental body, and any formal actions that you take have to relate directly to the massage therapy program and our licensees. Now let's talk about notice. Because as I mentioned a couple minutes ago, the act requires that you give the public advanced written notice of the date, time, place, and subject of all of our meetings. And so that is why we provide the agenda. And the agenda has to be filed by the Texas Secretary, has to be filed with the Texas Secretary of State at least 7 days before a meeting. And it must be posted online by both TDLR and the Secretary of State. Very important thing to remember is that the board or any committee cannot engage in discussions about a subject that's not included in the agenda. So it has to be officially noticed. It has to be on the agenda. Otherwise, there cannot be any discussion about that. So let's talk about some key points, and let's talk about something that often we receive questions about. It's, well, what happens at social functions, conventions, and workshops? Pre-COVID, I think you guys would often see each other at various places for conventions or social functions or things that were happening, continuing education. And so we often get this question of, well, what if most of us or all of us are there at the same time, or what if only some of us are there? So the important thing to remember is that a meeting as defined under the law occurs whenever a quorum engages in discussion about an issue that's within your purview, within your jurisdiction. Okay, so can members ever meet in an informal setting without violating the Open Meetings Act? The answer is absolutely yes. That's why we tell you all to be very careful and to be very mindful of a quorum. Members are free to engage in conversation that's incidental to the event. But if you're going to talk about business and there's a quorum involved and you engage in a discussion or make a decision about board or committee business, or you take formal action, that is engaging in a conversation outside of a properly noticed meeting. So the key points for you all to remember are to always be aware of any situation that is outside of a properly noticed meeting where there is a quorum of members present or engaged in a discussion. Don't engage in substantive conversations relating to board or committee business when a quorum is involved and you are outside of an officially noticed and scheduled meeting. One very important piece of this is the walking quorum. So a walking quorum occurs when there's fewer than a quorum of members discussing official business, and then that discussion is communicated to other members or to members of the public. So while fewer than a quorum of members participate in the initial communication, subsequent communication with other members will result in a quorum discussing official business outside of a public meeting. So let's talk about that. Let's give you an example. If you have a 5-member advisory board and 2 members exchange phone calls and emails talking about an upcoming rule change and perhaps exchanging research that they've done, and then one of the board members subsequently forwards the exchange to another member, the members have now engaged in a walking quorum by engaging in a small group discussion, right? So out of 5, there's 2 that are talking, then you have engaged in a walking quorum. All right, so when can walking quorums occur? Really anytime. So that's why we ask you all to be aware always of this issue of the walking quorum. Some examples are conference calls, video conferences, hallway discussions when we meet in person, if we ever resume meeting in person, and we see these discussions happening in hallways on breaks, that can possibly be a walking quorum. Emails, text messages, and other new technologies. New technologies is where we ask you to be especially careful. Twitter, Facebook, instant messaging, anywhere where you're going to post about board business and there's a possibility of other members of the board seeing that conversation. So in order to avoid a walking quorum, you shouldn't meet in small businesses to discuss, meet in small groups to discuss your business and then communicate that discussion to other members. Send emails or text messages to a quorum of members regarding official business, even if each email is addressed and sent to each member individually. What matters is the fact that you're having these communications with folks outside of an officially noticed meeting that regard your official business. So you can't get around it by saying, well, I'm not going to send a group email. I'll send it to each person. It's still not a good practice, and we ask that you not engage in that. We talked a little bit a few minutes ago about posts on social media. So be very careful about that when you're posting about business that is before the board or business that might be before the board, and you are in a public forum such as social media. That can also trigger an accusation of a walking quorum. All right, and lastly, ask a quorum of members. Don't ask a quorum of members, even on an individual basis, for feedback or comments on business relating to your board outside of the public meeting. This is called polling, which is essentially conducting an informal vote on the issue. So guidelines for open sessions. I talked a little bit a few minutes ago about limiting the discussions to specific items on the agenda. And this is why during the public portion of the meeting, when the public is speaking, you cannot respond to that person unless that agenda item is on, or unless that issue is on the agenda. So members of the public, as you all know, are given an opportunity to speak, and our presiding officer, in this case, Chair Lauterstein, set reasonable limits on commenters. So that is why you'll often hear him say, you're limited to 2 minutes or you're limited to 3 minutes. That's all allowed. And a member of the public or a member of the board cannot raise a subject that's not been included on the agenda. Now they could comment on it, but there cannot be any kind of discussion about it. Again, that's why we say you cannot respond back to somebody who's raised an issue that's not on the agenda. But at the end of the meeting, when you're discussing future agenda items, the board could decide to go ahead and put the subject of the comment on the agenda for a later meeting. And during that later meeting, you can have a robust discussion about it. So best practices for our sessions, for our meetings: limit discussions to the specific agenda items contained in the agenda as it is on file with the Secretary of State. Avoid discussions regarding specific agenda items. Avoid them wandering off into new issues that have not been noticed to the public. That one is difficult because you'll often have issues within issues within issues. So the important thing to remember is you've got to stick to the issue, the main issue, as it appears on the agenda. And don't respond to or discuss issues raised in public comment. And make sure that if you'd like to talk about something that has been raised, make sure you speak up at the end of the meeting when we're asking for possible agenda items, because that possibly could appear at a later date. All right, so what are the penalties for an Open Meetings Act violation? First of all, any interested person can petition the court to stop action taken by a governmental body that violates the Open Meetings Act. And it also states that an action taken in violation of the act is voidable. So that is why we want to be very, very careful that we are complying at all times with the Open Meetings Act. If you all take a vote and you pass something, we don't want that to be to wind up being questioned or called into question by any interested person. And I also note any interested person could be the media. Anyone could try to stop us and say, no, this violated the Open Meetings Act and you actually don't have authority to do this at this time. So what are the penalties? There's possible criminal penalties. If you knowingly participate in a walking quorum or you knowingly participate in a meeting that is closed to the public, you are subject to misdemeanor penalties with fines of $100 to $500, confinement in county jail for 1 to 6 months, or both the fine and the jail time. And so I think we have talked about best practices. You will see a slide that says Open Meetings Act resources. Please feel free to click on any of those links as they're provided in your board materials. Those will take you to some very informative sort of primers that the OAG, the Office of the Attorney General, puts out. You'll see a training and some videos. They also have a very, very good handbook. It is very long, but it covers in great depth the Open Meetings Act, and it's very helpful. The Administrative Procedures Act, let's talk about that now. The Administrative Procedures Act is the second law that you're receiving training for today. And what is the purpose of it? We call it the APA, the Administrative Procedure Act. And it's basically to establish uniform practices and procedures for state agencies. And really, it is the primary tool that we use to allow the public to participate in transparency during rulemaking, which we're going to see today. The APA defines a rule as a statement of general applicability that's made by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. So the rules for you all: put into practice your governing statute and provide all kinds of direction and parameters so that licensees are aware of what they must do or what they can't do. All right, so a rule excludes a statement that only pertains to the internal management of a state agency like TDLR, and it also excludes anything that doesn't affect private rights or procedures. A rule will include a brand new rule, an amendment to an existing rule, or a repeal of an existing rule. And the sources for rulemaking come from a variety of places. They come from the legislature and their work over there. They come from our advisory boards, they come from staff, they come from a 4-year rule review, which your program is getting ready to undertake. And we will notify you and provide you with more information on that. And they can also come through a rule petition. Rule petitions are very interesting because rule petitions can be submitted by any, quote, interested person who wants to see a particular issue addressed by a rule. And any interested person is basically any Texas resident, any business entity located in Texas, any other government subdivision in Texas, or a public or private organization that is not a state agency, but that is located in Texas. So as you all know, those of you who have been on the board for a while or have followed our meetings for a good amount of time, the rule process is very involved, and there are many, many steps to it. So we've provided this chart for you all to sort of get a firsthand synopsis view of what a rule encompasses. It's not just drafting, it's not just ideas. There are layers of review and analysis that go through. We present it first. We present our first draft to the advisory board. You all will decide whether or not to publish that. There's then a 30-day comment period. The agency will then review any comments that have come in, and then we go to a second advisory board meeting. That is what is happening today with the distance education rules. We are now at our second advisory board meeting. We will discuss the proposed rules. You guys will decide whether or not you want to take it up to the commission to allow them to review. And then the commission, of course, gets a chance to weigh in and decide whether they would like to adopt it or not. And then there are things that happen behind the scenes with notifying the Texas Register and us having an effective date of the rules. Long, involved process, and we are always happy to explain it and walk you all through it so that you understand at each step what is happening. So here we are. You mentioned that, or I mentioned that you all will soon be going through your 4-year rule review, and you will soon receive notice along with everyone else of the intent to review. And then there will automatically be, once there is notice of intent, a public comment period of 30 days. And during that public comment period, the public can pretty much say whatever they want to say about the existing rules or about ideas that they have for rules that they believe will fill in any gaps that they perceive. But we will get sometimes hundreds and hundreds of comments in various programs. Then what happens is that the assigned GCs, in this case Molly and myself, will review all of the comments, and then we will make a recommendation to the commission on whether to adopt the rules. And then of course it goes to the commission and all of those things. So again, the 4-year rule review is a overview of all of the rules. What you're normally used to is seeing us present a set of rules that may address a specific topic. In a 4-year rule review, all of the rules are open for possible amendment or addition or repeal, as I mentioned earlier. It is an interesting process, and we look forward to working with you guys on that upcoming review. So some of the rulemaking resources, again, these come from the OAG and also from the government code. These are the applicable statutes that you'll see the links for, the Secretary of State website that you'll see the links for, and of course the General Counsel's office. Always feel free, if you have a question about rulemaking or the Administrative Procedures Act, whether it's applicable to a particular thing, feel free to send an email to myself, Molly, and Mary, and we are happy to provide you with a response. And the final act that we want to talk about is the Public Information Act. This is the act that most people are familiar with because this is the one relating to information and what is available for the public to see and for the public to receive. So what is the intent? We call it the PIA. What is the intent of the PIA? It's to allow access. It's to allow access to the inner workings of government and the official acts of public officials and employees. And what it does is it makes all documents, records, and other information, which could include audio recordings, video recordings, Anything that's related to official business, it makes it open to the public with some exceptions. It includes any electronic communication created, transmitted, received, or maintained on any device if it is in connection with official business. Let me stress that. Any device. It does not have to be a TDLR assigned and issued device. It potentially could be your own devices. So be aware of that when you're communicating, that if we get an open records request, we might, our open records attorney Mia Settle and her folks may come to you and say, do you have anything on any device related to official business? If so, we need it. The Act is construed liberally in favor of granting requests for information. So that's also something to be aware of. If you receive a written request for records, because the Act requires the request be written, then what we need you to do is go ahead and forward that to the Office of the General Counsel and to the Open Records team. And if either myself and Molly or Mia or any of her staff request information from you, we need a response as quick as possible. We know you're busy, but if you can get to that as soon as possible, we greatly appreciate it. What we do is we respond to the request as soon as possible, but not later than 10 days after receipt of the request. So it's super important that we respond timely and efficiently to the public, and that we make sure that we have gathered all of the responsive documents. And we can't ask why someone wants records. We can only ask for clarifications, and that's done through the GC Open Records team, Mia Settle and her people. So if you get a request for records from somebody, just remember we cannot ask why, but you should forward it on to us and we will review it, and we will determine, Mia will determine how we respond and what is actually turned over. As I said earlier, remember, there are some exceptions to everything being open, and we will look at those on a case-by-case basis. So some of the common exceptions or exemptions are dates of birth, some email addresses, certain education documents, HIPAA-related information, or information that's under the Texas Medical Records Privacy Act. But again, we need all of the records so that Mia and her team can decide what exemption applies. So if you'd like more information about the PIA, again, we have some training and some videos, a link to training and videos from the Office of the Attorney General. The handbook, again, also has some great information on the PIA. That's the handbook that I talked about earlier in regards to the Open Meetings Act. And then the Texas Government Code, Chapter 552. You can read the actual statute for the PIA. And now we are doing something exciting, which is in the past, we used to sort of transmit electronic records to a requester via email. And now we have our own Open Records Center portal. That is something that is a recent development at TDLR that Mia and the agency are very proud of, that we're now able to offer. It provides us with a more efficient way of responding to open records, and it also provides us with a more centralized way for those open records requests to be submitted. So if somebody approaches you and says, hey, how do I send an open records request to, who do I send it to in TDLR? Feel free to give them this link and allow them to go ahead and submit through the portal. The link that I've provided there will take you to the portal, and there will be instructions on how you submit an open records request. And with that, we are done with the training. Do you have any questions? I know there's a couple of fairly new board members. Is there anything that you need for me to clarify, or do you have any questions?
Board members? I would just like one clarification or one
Yes.
or two. So if I call one board member or they call me, as long as it's just two people talking and nothing is shared with any other board members, then that is allowed, isn't that correct?
It is.
Okay.
That would be allowed.
Yeah.
Where you have to be careful is when you start adding on, or where somebody, let's say you all were talking over email, and that person were to forward it without you knowing to another member of the board. So, and then that gets forwarded. So you can see how quickly a one-on-one conversation could blossom to an actual walking quorum.
Yeah,
But
I completely understand, but thank you. That's clear.
David,
Yes.
Russell Rust.
Russell?
Yes, Mr. Rust?
Yeah, just one quick question. There is no problem with posting information that TDLR has sent out for the social media, such as my AMTA Facebook page. It's just additional information that y'all have already sent out to everyone, but I just want to make sure that everyone sees that there's nothing wrong with reposting something that's already been put up on the front page or on the massage
That's
page,
right. If you're
correct?
reposting something from TDLR that's been put out for informational purposes, and you're simply reposting it because you believe that some of the audience may not have seen it on the TDLR webpage, that's totally fine. But let's say, for example, somebody, and I won't say you, Mr. Russ, but somebody gets on there and says, well, board member, what do you think about the agency's position on X? And it's on Facebook or it's on Twitter. That's when you have to be very careful. So often the agency will make announcements on that TDLR massage webpage about things that are happening within the agency. So if you post that on social media or in a board or in some kind of discussion group and somebody starts to ask you about that, that's when you need to be hyper aware of possibly engaging in a walking quorum. If other members of the board also have access to that conversation or could potentially have access to that conversation. And I got a message from our friend Jerry Gonzalez. He said to also remind you, stress a little more this issue of polling. So we don't ever want to start asking folks, how do you intend to vote on this? If you want to have your one-on-one discussion, share your research, that's fine. But let's not get into the conversations of, well, I think that I'm going to go ahead and support it, or I think I'm not going to support it.
Yes, thank you for that clarification.
Mhm.
And is that portal that you just mentioned going to be prominently mentioned on the website so that the public can be aware of that option now?
Yeah, it should be there. We've been using it for a few months. That link that I
Okay.
provided you will take you directly to the page where you can start, you will learn about the portal and it'll give you instructions for what to do.
Great. Yeah, I just hadn't
Follow up
noticed
on that. Would that also be where we would get addresses of schools and the licensed therapist, or would we still have to go through the other open records for that information?
Okay, so there's only one open records division, and right
Okay.
now they would like all of the requests that come in, they want to be funneled through the portal because that's how we check
Yes, ma'am.
and keep track. You know, we don't want anything to sort of fall through the cracks. And so this portal is wonderful because it prevents that kind of stuff and it ensures that the request gets to the right team at TDLR, which is our open records team that's led by Mia Settle.
All right, thank you.
Mhm.
Very good. Again, David Lauderstein, are there any other questions or comments? Yes.
Those of us who are in more than one sector, such as cosmetology as well as massage therapy, is it okay to speak with board members from other professions?
Y- You can, but you again have to be careful of becoming engaged in conversations that could be a walking quorum. So you can, I know that massage therapy and bar cause often overlap and you have some similar issues. You could have some of those informal discussions, but if you're going to talk about formal business that's before either board, I would be extraordinarily careful with doing that. And if you have any questions, always feel free to email myself or Molly or Mary. Hey, I'm going to go to a conference and I want to talk to the board member on the bar cause board about this issue that crosses both programs. Can I do that? And we're happy to provide you with direction on that kind of stuff.
And Mary Winston TLR, I want to thank you, Ms. Taylor. That's a new one.
It is.
Elizabeth's been doing this a while. And I'm like, ooh, a twist. So
That got me, Mary. I was like, oh.
Yes.
This
And
is a tough one.
honestly, it is. And advisory.boards, we have 4 folks that check that, and we will get anything. If you can't remember anything else, that's where you get your emails for this meeting. We will get it to staff. We will get it to Elizabeth and Molly. So no worries, but great question. Thank you.
Good. Right, if there are no more questions or comments, thanks very much, Ms. Selena Strittmatter. Thank you.
Thank you.
Yeah.
Thank you. I appreciate that.
Good. And now, the next thing on the agenda is ordinarily a public comment. And we're happy to take those. In this particular case, we haven't got any public comments for this meeting. So we'll move on to the next item on the agenda, which is,
Sir, I'm sorry to interrupt.
yes,
We need to do item E, approval of minutes.
I'm sorry.
Item E, approval of minutes.
Oh, yes, I'm sorry. You're right. So skipping ahead there. So I would ask a board member to make a motion and then to see if there is a second to approve the minutes of January 21st, 2021.
Tony
Russell
Grassi, I
Rose, I'd
move
like
to
to make a
approve the
motion to
minutes.
approve the minutes.
Russell
Carolyn
Ross,
Guerin, board member, I'll second it.
Carolyn Guerin seconds that motion. And is there a discussion about that? Okay. And Anna, could you please tally the vote?
Yes, sir. Russell Rust,
Yes.
Carolyn Guerin,
Yes.
Carol Willis,
Yes.
Antonio Gracia Jr.,
Yes.
Kitra Taylor,
Yes.
Callie Morris,
Yes.
and presiding officer David Lauterstein.
Yes, thank you very much.
Yes, sir. Motion passes.
Okay. So now we could move on to discussion and possible recommendation on the proposed amendments to the existing rules at 16 Texas Administrative Code, the various chapters listed in the agenda. So this is, I believe, going to be Molly Fudel leading this discussion. And so I hand over the microphone to you.
Thank you, Mr. Lauterstein.
Mhm.
Good afternoon, board members. Molly Fudel, Assistant General Counsel here at TDLR, and I'm going to be presenting the rules for you today. These rules do several things. They implement SB 1130 regarding distance learning. They also implement HB 1540, which amended the definition of sexual contact in the massage statute and the penal code. And they also make changes in response to violence and other misconduct against massage therapists that's happened recently. And they make some clarification and cleanup changes. So I'm going to go ahead and go through them. These rules were published in the Texas Register for public comment. We received 17 comments during that comment period, which is a good amount, and we thank everybody for submitting their comments. So the comments were from a lot of different viewpoints. There were some people who liked the rules as published. There were some who wanted very few requirements when it came to distance learning. And then there were some folks who just didn't want distance learning at all. So what we were going for, and I think what we've achieved here, is some rules that will ensure that students get the instruction that they need, while also giving schools and students the flexibility that was intended in this bill, SB 1130. And we're also using the federal rules as a model here. The Department of Education has been involved with distance learning for a really long time, and so they've seen what works and what doesn't work, and we've adapted those for our rules. So I'm going to go ahead and go through the rules, and I'm going to share my screen. So if you have any questions, please go ahead and speak up, because it's going to be very difficult for me to see you. Okay. All right, here we go. So you should have the rules in front of you. The red text is the changes that we're suggesting in response to comments. So here first, and yes, go ahead. Did somebody have a question? Okay, I apologize. I thought I heard something. All right. Here in 117.2 in definitions, we didn't have any comments related to the definition of distance learning. I'll go ahead and scroll down. In 117.50, we did have some comments. One commenter liked that approval is going to be required before providing distance learning. There were also several commenters who focused on the requirement for a school that's already been approved to obtain additional approval if they want to change their technology or offer additional courses through distance learning. And the commenters spoke about how this requirement would really limit the school's ability to be flexible and adapt. So department staff considered this, and we tend to agree. And so what we're recommending is that we change the language in this rule so that a school that's already been approved for distance learning can go ahead and make the changes that they need to make. They just have to notify the department afterwards. And we think that this will give the schools the flexibility that they need, and it also give the department the information that we're needing. Okay. 117.55, oh, sorry, go ahead.
No, just clearing my throat.
Oh, okay.
Unmute me.
117.55, we didn't have any comments. We didn't have any comments in 58 either. In 59, this is where we had the majority of the comments because this is where the majority of the changes were. So I'll go through them. We had a comment on subsection D right here about the instructor being physically present. A commenter wasn't sure why we were putting in the language for in-person classroom hours. And just as a reminder, the reason why we're doing that is because we wanted to distinguish between the physical classroom, the in-person classroom, and a virtual classroom. We had some comments on E. This is a subsection that focuses on the internship. Some commenters stated that the internship should be allowed off-site at a place other than a massage school. Department staff tend to disagree and believe that this goes against the intent of the massage statute as well as the rest of the rules, and that it's also relevant to public health and safety. There was also a question about this subsection and referring to 40 hours during the internship when 50 hours are required. And this subsection is referring to the 40 hours of hands-on in that first sentence, hands-on massage therapy experience. So the internship requires 50 hours total, but 40 hours of those have to be hands-on, and that's from the statute. In subsection F, we had a comment, and the comment said that the instructor should be allowed to be available through electronic communication to the student who's completing the internship. We tend to think that it's important, though, for the instructor to be on site so that they can physically step in if they need to. So we'd like to keep that, that text as it is. I'm going to scroll down to M. This is the subsection that pertains the most to distance learning, has the most relevant rules. And I'll scroll down here to 4. This is where the comments really started coming in. The commenters mainly wanted some clarification on this requirement for an opportunity for direct interaction between the instructor and the student. So there were lots of questions about what does that mean? Does that mean that the instructor has to respond immediately? And if so, that would really work against the intent of SB 1130, which says that live instruction is not required. So what we've done is we've added some clarification here, and we're saying that the instructor doesn't have to respond immediately, but it has to be within a reasonable amount of time. And you'll see that we're using these terms synchronous and asynchronous. These are used in the federal rules, and they're terms that are widely used. So we thought they'd be appropriate here.
Molly?
Yes, go ahead.
Of course, there is no specificity then to saying reasonable amount of time. I just have a question about the unclarity of that.
Yeah, and we recognize that that's not as easy to implement as, you know, if we said has to respond within 15 minutes, 20 minutes. You can easily determine the amount of time. But we thought that it was more important to come up with something that would account for various situations that come up. You know, sometimes it might be appropriate just for the response to be a little bit longer than other times because of school holidays, just things that are going on in the world. And so this is something where if you know it's going to be working with the students, and if the school does their best, they really shouldn't have anything to worry about.
Yeah, I understand. Still the issue is there's no definition of what unreasonable would be. And I just have a wonder about that. So
So,
just
Mr.
as a,
Lauderstein, Mary
yeah.
Winston, I wanted to jump in. So, we legal folks, we like to talk about what's reasonable and the reasonable man standard. And so that is the foundation of a lot of laws. What is the reasonable man's standard? And what was reasonable before we had the pandemic may not have been reasonable during the pandemic, which may be more reasonable now. I know we're not quite out, but I'm rooting for us. So we have the freedom to take those things into consideration without binding someone to, as Molly said, 15 minutes or 5 days, because we can consider that. So it's looser, but trust me, it's graspable for our enforcement, for us to handle because it's a standard we're used to working with.
Okay, thanks very much.
Russell Russ, one question on that. Would the student have availability to complain if they did not feel like they were getting an answer in a reasonable amount of time? Because they are the ones that are paying the tuition. Some people are more needy than others. So for them, a reasonable amount of time may not be 5 minutes, but we're back to that situation. I'm just saying that is in protection of the student that's actually paying for the education. You know, what is a reasonable amount of time? If they're only able to spend so much interaction, they may need an answer there because they may have to go to work for the next 3 days on a shift. I don't know how these schools are going to set up their schedule, but that was one of my questions.
If Molly, if I may just add, the determination of what's reasonable or not is very fact specific. It's driven by the facts that exist in the context in which they exist. So when Mary says we kind of use that reasonable man standard, what that means is that we're going to take the context in which that occurs, look at the facts, and determine what is reasonable, what is not reasonable. I can assure you that our enforcement folks are very reasonable in terms of looking at whether something was timely responded to or not timely responded to. We understand the constraints of time. This is just something that we don't want to quantify because, as you've stated, Mr. Rust, for some students it's this and for some students it's that. So we look at the facts surrounding the instance and we decide based on those facts what's reasonable and what's not.
So one follow-up that, would there be anything that a school might need to put inside their catalog stating what they're going to determine reasonable time is so that a student can have an anticipation and know that they must wait for this answer a certain amount of time? Just curious.
They could certainly do that.
Yeah,
Now that
Jerry,
would control. Go ahead.
I'm sorry, Jerry Gonzalez, RPM. Russell, yeah, that I was about to suggest that each school is going to have their own, I guess, time. But like as Elizabeth was saying, it's depending on the type of circumstance that may arise with that question. But a lot of people say, hey, I'm going to have every day from 2 to 3 availability of all my instructors. Or you could have a policy that we're going to respond within the hour or 24 hours. Again, it's going to be dependent on the school, and they could set their own parameters per se, but so long as it's again within reason and depending what the issues may be in question.
Thank you very much.
Thank you. Okay, so I'll move on to subsection 5. This is another area where people in general just wanted more clarification on what we meant. So when we published this, we said that the instruction, when it's something other than live instruction, has to be interactive. And so what we've done here is we've replaced that with the term that's used in the federal rules, which is academic engagement. And we've taken the definition of academic engagement directly from the federal rules. We think it describes exactly what we were going for and gives a description to our licensees as well. So you'll see also that this subsection, it used to be one, we've broken it up more. That's because some of the comments were confusing the two requirements, the one for opportunity for direct interaction, and then the one for interactive instruction or academic engagement. And we think that by doing it this way, it makes it much easier to understand. I'll go ahead and scroll down. There's also this list. It's a non-exclusive list of acceptable activities. And we had some comments with suggestions on what to put here. One was that we put completing and submitting an academic assignment. You'll see that in B. And we agreed that was a good addition. So we went ahead and put that in, in response to the comment. There was also a suggestion to add completing a reading assignment. We didn't really think that captured the spirit of what we were going for, so we decided not to add it. I'm going to go ahead and scroll down. Excuse me. Here in what's now subsection 6, you'll see that we renumbered these since we broke up the subsection that was above it. In subsection 8, it says that a massage school may not use distance learning to provide the instruction required by section 455.156B1A of the Act. That's the section on massage therapy theory and techniques and the practice of manipulation of soft tissue. So we had a commenter stating that they believe that these hours should be able to be taught through distance learning. But we are recommending keeping the language as is, simply because these hours are hands-on hours, and this is a hands-on profession. So we believe they're best taught in person. In subsection 9, we had a comment about the time clock, and somebody pointed out that errors are to be expected, and we agree. We think that the language here adequately addresses the students and the school's ability to figure out a system that works for them, so that they can keep track of student hours and but also account for any errors should they arise.
Russell Rust.
Go ahead.
Now, on this distance learning, so for instance, I have a set class schedule that I do now. So they're here in the class. Let's just use an example from 9 to 12:30. For somebody doing distance learning, is there still going to be a set schedule, or is this something they're just going to sign in, sign out, do 10 minutes here, an hour here, do it at 2 o'clock in the morning? So how is that going to be? You know, I'm sure people could do it. I would have a very hard time trying to figure out if they're getting the number of hours, especially when a clock hour is 50 minutes. Seems like at least they would have to spend at least 1 hour in a subject or online or webinar or whatever it is, because if they do 15 minutes here, 30 minutes there, they're driving home in their car and they do a little bit. I'm just confused, and maybe, you know, that was the question I had to begin with, regardless of what we're going on now. So
Yes, and it'll be up to the school to figure out how they want to offer their courses through distance learning. So regardless of whether those hours are scheduled or not, the school is still required to, to accurately track those hours.
So if a clock hour is 50 minutes, they can do 10 minutes, 10 minutes, 10 minutes, 10 minutes till they get to a clock hour of 50 and give them credit for 1 hour?
Yes, sir.
Yeah, Russell, Jerry Gonzalez, RPM. I guess the first thing that we need to remember, or that's out there, is that this is only for schools that may want to offer it. You don't have to offer. This is just another option to present to be able to give appropriate training to students that way. The other thing with that is the school needs to then identify how they're going to be offering their coursework, And there's going to be increments where they check off time that equates to your, like you said, 50 minutes or full hour before you can actually give them credit for that. So it's going to be how the schools set it up, how they can do it. And if it's a prerequisite before a next class, the timers should be built in of some sort on how you're going to provide that. But again, it's an option. It doesn't have to be done. All 500 hours can be done at the school itself.
Okay, I understand the hours being done. I just know I have a contract with a student that has a start date and an end date. You know, I don't know how a school is going to control a student if there's not a set time for them to be able to do that. And apparently they don't have to set a time. They can let the student just come in, go as they please.
Mr. Taylor, I wanted to I know I missed it earlier, but one of the things that kind of ties into this is you were talking about within reasonable amount of time, that kind of thing. Does this provide the structure for office hours where we'd have specific hours that we would be available to the students, that kind of thing, to make it a reasonable amount of time?
Absolutely, yes.
Russ, Ray Pizarro, Director for Education Examination Division. Russ, I believe what you're asking, and I understand where you're coming from, but remember, the agency is looking at the schools and relying on the schools and their instructor or instructors to offer the curriculum in a way that is conducive to learning, right, to all of the students. As you heard before, this is an option for the school, but we are relying on you to offer that curriculum in a manner that's conducive to learning. All of these schools who are going to engage in distance learning, they will have to submit to the Education Examination Division what and how they are going to be delivering this piece of theory portion via distance learning. So I just wanted to point that out. We are relying on you, Russ, and all of the other schools if you engage in that alternative method of delivery.
Okay,
Thank you.
Ray, but above that, you just said that a school can implement anything they want, then give it to you later. Is that, you said it was going to be approved, but then you went back and changed it in the rules previous that would be a burden on schools, so they can go ahead and implement anything they choose, and then they can get approval for it. Well, what happens if they implement something, they send it into you for approval, which they're already doing it for their students, and you guys come back and say, we don't quite like it like that?
I believe
understand what I'm asking?
Molly, I believe what Molly was saying in that piece of the rule was that you are approved, and during that approval process, during the time frame that you have been approved, you decided to use a new platform of virtual, let's just say, versus an old platform that you were using, and you say, you know what, I'm going to switch mine to do this. And so I'm going to go ahead and switch it. I'm still doing the same amount of hours and the same type of hours of the curriculum via online, but I've changed the platform and the virtual setting on how I'm delivering it, and I'm going to tell the department thereafter. I believe that's in the rules that Molly was explaining. That's what she was talking about.
Right.
You're just
Yes.
talking about the platform of delivery can be changed without getting permission prior to changing the platform. Okay,
That is
that's
correct.
not how I understood that. So, but that's okay. That doesn't mean, but I think then there needs to be a little more clarification. I mean, maybe the other board members asked them if they understood it like that. That is not how I understand that. That's for the platform use can be changed and notified at a later time.
I'll go ahead and scroll up and we can take a look at that.
Okay.
Yeah,
And
as
I
you
could
do
I could
that-
just be reading too little or too much into it. It's okay. I'm just wanting clarification.
Just as you're doing that, I want to kind of dovetail with some of these questions. And Ray Pizarro, I think it would be wonderful if you all would indeed be looking at how are they going to be accurately tracking the students' attendance in a distance learning context? Because there's so much room for abuse, as Russell's implying, that it would be really nice to know that TDLR is looking at their methodology before they go ahead and start offering it, as Russell says, in 10-minute increments or who knows what. So it would be nice to know that there was something there that could prevent abuse of the way the hours are being tracked.
Right, so here in 117.50K, the first sentence stayed as it was. A massage school must obtain department approval in writing before offering instruction through distance learning. A school must notify the department in writing when changing the technology or method of providing distance learning or offering additional instruction through distance learning.
So Molly, could that include how they are tracking hours?
It could, yes, because the technology that's used to track hours is right there, technology for providing distance learning.
Yeah. I think we're
Hey,
saying
Molly,
we'd
and
like
I
to see that
apologize. I
communicated.
was really focusing on the red. I see the sentence above that. Okay. I'm sorry. I was really focusing on the red because I'd already read through these. I don't remember getting these ahead of time to take a look at. So my error there.
Thank you. I appreciate the comments.
And thank you all for your patience with our comments. I appreciate it.
Yeah, I'll go ahead and, sorry, go ahead.
Just a question on the part back up here where we're all asking about obtaining approval. Are the schools then allowed to provide a syllabus, meaning I have a syllabus in which I'm going to say this is all contact learning. This is a syllabus for a hybrid kind of course, if you will. And these are the requirements, and these would be outlining what the reasonables for the student and how everything is tracked. I mean, would that be what you're looking for TDLR to, a school to submit that? Is that what we should be define what those things are, parameters, when they're
Yeah,
sending that?
the school is free to set up their instruction however works best for them and their students, as long as it complies with the laws and rules, which what you're describing would.
Okay.
Okay. Right. I will scroll back down. I believe we're at the end of 59 and okay. So moving on to subsection N, and this talks about the information that a massage school would be required to provide within that 500-hour supervised course of instruction. And it would be information in protecting the safety of the massage therapist. We received several comments in support of this. And we wanted to clarify this is for all massage schools, not just those that provide distance learning or do not. So even though it's part of this package, it applies to all massage schools in Texas who are licensed through us. I'm going to go ahead and scroll down. 62, we didn't receive any comments, and I think we did not receive any comments in 66 either. Okay. In 67, we received a couple comments regarding subsection B. This sentence here that the department may require massage schools to identify the location where hours are completed, or if they're completed through distance learning. Staff believes that this sentence is necessary. We think that this is information that massage schools are compiling anyway, and so the burden of reporting it wouldn't be significant. The department would also like to be able to use this information to understand exactly how many hours are being offered through distance learning. Go ahead and scroll down. Go. In 117.68, we had a suggestion to add the words "if applicable" in subsection C. We don't really think that's necessary. We think that this subsection covers schools who have scheduled instruction, or if they don't have scheduled instruction. believe that's the last of the changes for distance learning. The changes in 11782 implement HB 1540. So I'll go ahead and scroll down. It's a very small.
Molly, it's Russell. I'm
Yes.
sorry, I had the wrong thing going on. I am concerned, or not concerned, with distance learning, what is going to constitute an absence? If there is no scheduled time for a class, there is no, what is going to constitute what an absence is? And that absence being made up. Now, I know the policy has changed that we do not have to drop a student after 15% of the program. That's left up to the schools, you know, for their own admissions or whatever. But what is actually, you know, and I'm just going to use this as an example. What if you have a school that is having an in-person class, an in-person schedule, and somebody's an hour absent or a day absent? Well, I can go online and I can do it distance learning for this school, and they never count you absent because you can do it at any time you choose. I'm real confused on how that, you know, I know you're leaving it up to the schools, but then absences, if they're never counted absent, and I promise you, I run classes, I've had one student or two over the past years that never missed any time, never were late, but the majority of them, a minimum of probably for the duration of my program, I would say at least 20 hours is missed in a regular session. Now they make all the hours up, but that's a minimum. So if somebody, and I'm just, you know, and this could be a competition or not a competition, but what is the word I went? Choosing this school over this school. I don't know what happened to me with my words. But I go to this school, if I miss an hour, I got an hour of absence. But if I go to this school, they never have attendance, so therefore you're never absent. So I'm really confused on that one, how that would be implemented.
Yeah, so as you were saying, it would be left up to the school and how they determine whether whether classes are scheduled, whether students have to complete a certain number of hours within a certain amount of time. So I want to point, I scrolled back up to point out this subsection 117.67A. So this is still in the rules. Appropriate standards must be implemented to ascertain the progress of students enrolled. So this is going to work with all of the distance learning rules in terms of the schools have to make sure that a student is making satisfactory progress. Are they going to be able to complete the subjects within the allotted time provided in the pre-enrollment information?
Okay, I do understand that, but I'm still telling you, you have a school that has physical classes and a school that has distance learning. You know, some of these students would choose a class like that because they would never be absent. Because that school really doesn't have a set schedule. I mean, they can do what they choose. And so they say the way our school works, you just sign in when you're available. So therefore, that eliminates attendance or absences. Yes, they will accumulate the attendance to successfully complete the program. But going back to what an absence is and having to make up that time as an absence, that is a direct advantage for one or the other.
In my experience, whenever you're teaching online, and the first 200 hours at TSPA are online only, there is still set hours that they have to attend, and I take attendance at the beginning of class and at the end of class, and they have, if they come in late or whatever, they have to actually, you know, put into the chat when they got there, or they won't get credit for their hours.
But that's a school being conscientious and looking at the student and following the rules. That's not the honor program.
Good point.
And that's what our schools are set up on, is an honor program, which I would hope most of the industry are honorable in what they do. But we have unhonorable people that are going to take advantage of that situation. And I do understand you can't overregulate. I don't want to be overregulated in what I do, but putting a cap or putting some kind of criteria there, I do think that would be taken advantage of. And I do not understand in the scenario that is written now how TDLR comprehend, or even in an investigation or a site, how that would even be relevant, because there is no standard by which to follow.
Russ, Ray Pizarro, Director, Education. I'm hearing what you're saying, and I'm still trying to understand where you're coming from with what you are describing. Because at the end of the day, the department is looking at, did the student complete the required hours? Not whether they were absent 10 times or 1 time. We're looking at, did you complete the required 500 hours? And if you did, you have met that requirement. I don't think there's a requirement to meet how many absences. At least with the brick and mortar, you guys are determining these folks did not complete the time, therefore you're going to have to come back. With the online, it would seem to me it's the provider, the school, is going to be tracking those students, whether they've completed or not. If they don't show up to complete it, they're not going to get credit for that online portion. So the bottom line is, if they didn't clock in, for example, for 2 or 3 weeks and they have not completed the course, they're not going to get credit. They simply haven't completed the course. If they clocked in frequently and they've done the work as provided by the education provider, then they have completed the required hours in accordance to the laws and rules. So I'm not following where we're going with one being an advantage over the other. I would agree. Yeah, there may be an advantage of online because now you're at home being able to take courses in a manner that would be conducive to learning and to the current setting or this current environment that we currently live in. And it actually helped folks. And I do understand there are certain things that cannot be done online simply because it's not achievable or cannot be measured properly to ensure safety. So I'm just trying to understand where you're coming from on the differences between a person not or school not being able to address absence or not absent.
Okay. Well, just flat out, my class is from 9 to 12:30. If a student misses an hour, then they've got to come back to the school to make up the hour. If somebody is doing classes online, there would never be that hour of missed time because it's flexible for them to sign in, sign out when they choose. So what's the point? Then they would not really be following an attendance program, maybe until they're following an attendance program, but they really couldn't make the student accountable for, let's say, that hour, because they don't have a physical part to be there. There is no requirement. So maybe a school does say, if we don't see you signed in from this time, you would technically get an absence. But when you're doing distance learning, does an absence really matter? So maybe I'm just saying, as compared for a competitive stake, you've got a school that's a brick and mortar, that if they miss Tuesday, well, they got to come back on another day to get those hours in. If you're doing it via distance learning and you wasn't able to sign in on Tuesday, well, it's not really an absence. You can just pick up that time at any time you choose. Does that make any more sense, or any of the other
Yeah, I
board
mean, I hear
members,
what you're
David?
saying, but I think it's just again, it's a different alternative method of delivery.
Okay.
And I don't think you can compare apples to apples because they're not. I mean, this is, and I think a lot of us are familiar with driving safety. For example, you get a ticket on the highway, you're gonna have to take a driving safety course, and it's a 6-hour course. You can choose to do it online and do the 6 hours, and that platform is gonna require for you to do every second of that time.
That's
Or
right.
you can go face to face with somebody that they do funny bone or different face-to-face option, and you can do that face-to-face with that provider. I mean, they're very different, yet they're the same, that you have to clock and acquire all of those required hours.
Okay, let
Thank
me just intervene for a sec. It seems to me, I'm understanding what everybody's saying. And for me, the overall point, if you don't mind me saying, Ray, is that, Raymond, is that I'm sorry, Russell, that there is probably a lot of room for looseness that makes us a little anxious about what distance learning schools may do with regard to tracking absences. And I'm just wondering whether the education work group could discuss a little bit of what are going to be, how could we help with criteria that when these schools are inspected, that there is some clarity on the part of the inspection team of, what the criteria is going to be with regard to the way absences are being treated. Obviously, it can be and should be stated by the school how they're doing it, but then how will the inspection team note that they're in compliance? I think it's an open issue and it's a wonder of ours naturally. And I'm just wondering if there could be further discussions, not necessarily um, during this meeting, but in the.
Mr. Lauterstein, Mary Winston, TDLR, fantastic. And we've had a fantastic discussion, and I think we've already provided a lot of information that can be discussed further in a work group. We've kind of laid it all out on the table.
Yeah.
And so segue to get us back on track to finish allowing Molly to finish out this discussion and moving forward with the meeting. But Mr. Russ, this is not done. We will further discuss the specifics. I think in a work group would be great.
Thank you, ma'am.
Great, thank you all, appreciate it. Back
Thank
to
you.
Molly Fidel.
Thank you so much. Okay, I'm going to scroll down. Here we are, 117.82. This is one of the changes implementing HB 1540. This is a bill that was designed to fight human trafficking, but most of the changes are elsewhere in other laws, not the massage therapy law. The only one that's relevant to us is that it changed the definition of prostitution in the penal code and also in the massage statute. So we are just updating the rules to match that. And we did receive comment in support of this change. In 117.91, we have a few changes here. And we received comments in support of these changes as well. So we're here putting a requirement for 2 additional statements in the consultation document. And these are designed to remind the client that the licensee can end the session and in some cases has to end the massage session. So lots of support for these. There was one comment saying that they would like for us to add language saying that when the licensee ends the massage session, that they cannot do so in a discriminatory manner. We note though that there are anti-discrimination laws elsewhere outside the massage statute and rules. So we're comfortable with leaving the text as it is right now. We also received a comment regarding this small change down here in B on when the consultation document has to be updated. This is just correcting an error that was already there. But somebody was thinking that the way that the rules are worded, that if a massage therapist changes their techniques that they're using during a session, that they would then have to stop the session and execute a new consultation document. That is not the way that the rules are written. We do not believe that that is the case. So I just wanted to address that as we're going through.
Okay, Molly, one thing back on 7. In the session, if a client initiates any verbal or physical contact that is sexual in nature, if they experience any physical contact or verbal abuse, whether it's sexual or not, the session could be ended. So I'm still opposed to the word sexual being on my client file. I don't see it on my doctor's client file, the chiropractor's client files, but that is still a word that's being presented here. And I do understand the environment that we're in, but sexual, we're professionals and putting that on our client file, I just disagree with the word sexual having to be on my client file. Thank you.
I agree with that.
Okay. All right.
I'm sorry, I would just say maybe something along the lines of inappropriate contact, or any kind of boundaries that are crossed. It could be, there are a lot of things that could be, put in here because it's a dangerous time for a lot of people in the sector, and to put those things out there, I can understand their thoughts on it. But inappropriate touch of any kind. And then maybe that can give a little bit of a boundary, crossing boundary, personal boundaries.
Molly?
Yes, go ahead.
Caroline Guerin, board member. I sent in what was on my form and it did not have the word sexual in it, but for any reason, the massage can end. And I don't know what happened to it. But I can resend what I have on my form, and it does not use the word sexual, which I agree with Russ. I don't like that word in there, and I really don't want it on my intake form.
Okay. And we've got in subsection 6, I think that covers what you sent in, Ms. Guerin.
Yes.
A statement that the licensee may end the massage session if the licensee feels uncomfortable for any reason.
Yes.
Okay, great.
Thank you.
Okay, all right. So we're almost done. I'm just going to go ahead and scroll down, and then it'll be time for you to discuss and make a motion. 117.92 is also the same change that was in 117.82, and it's implementing that new bill. And that's it. So I'm available for any questions that you have. Staff's recommendation is to recommend that you forward these rules to the commission with the changes that are indicated today. But I will stand by and await further discussion and motions.
One question, Russell Rust. Would these not have to go before public comment again since they have been reworded? Or the language has changed? Is that not appropriate for them to go before public comment once again?
They don't need to go before public comment once again because these changes are still within the same subject matter that were published.
Okay.
Yeah.
Okay.
Carolyn? Okay. I have a question. Are we not going to have an education meeting about what Russell discussed before this goes any further?
We don't have, so we have a deadline in the bill to implement these rules by December 1st. That's when the deadline for the commission to vote on them. But going forward, as Mr. Lauterstein said, it may be appropriate for a work group to talk about some of the issues that Mr. Rust identified and kind of how that would work with inspections going forward. Because even if these rules are adopted, we recognize the rules are always being refined. And we're always going to see things that we didn't quite anticipate. And so we rely on you, of course, as board members, and in this case, as school owners, to tell us what you're seeing and how these rules are working out in the industry.
And Molly, if I may say something, we're also going, as I mentioned in my presentation, we're going to go into the 4-year rule review. That would be another time. What we always suggest is when rules go into effect, giving our industries a length of time to see what problems, if any, exist, and coming back at that time, because we can talk about hypotheticals, we can talk about what we think might happen. Sometimes in rules, you have all these fears, not you in particular, just generally, there are fears about things that might happen. And then we see the real world when they play out, none of those things come to pass. And I'm not saying that's going to be the case here, but we have the 4-year rule review. That would be another opportunity for the public to comment. Because remember, I said in my presentation that the 4-year rule review, the public can comment on all or any of the rules. So that would be an opportunity.
I have one comment. So as what you just stated, going forward, we will see how these rules play out. But we are going to be transparent. We are going to know from the inspectors, from the inspections that happen, what circumstance and what things are being abused, and they are going to be looked at. That's all I'm asking. Because it hasn't quite worked out like that so far with dishes or TDLR. So I do understand Yes, I'm being hypothetical, but I've been doing this for 26 years now. So I do understand what the industry, I see the schools, I see what's going on. So going forward from this point, presenting these rules, there will actually be some accountability going forward. If there are abuses in these rules, how we can adapt or change those to solve those abuses. And that's what I'm asking of right now.
Right, and Mr. Russ, and I totally understand that, and I get where your concern lies and where your heart lies. Anytime there are any concerns about violations of statute or rule, please send us a complaint. That is how enforcement initiates our investigations. That is the protocol and procedure that we follow at TDLR. You know, so if
Elizabeth,
you
could I add something? Sorry to interrupt you,
Absolutely.
but Mary Winston, one good thing, Miss Guerin, is that sometimes a rule packet, most of the time, does not accompany or come so close to a 4-year rule review. So once we get past this one section, we open up this whole part of the rule. We open up the whole set of rules for massage. So, and Mr. Russ, we have some of the greatest board members here at TDLR for all of our boards, and you're one of them. And I know how passionate you are, and we will hear from you day one. And that's good. That's good. That's why we have you here. But I did want to let you just kind of highlight, yes, Elizabeth kind of covered that when she was giving us the update and the new training. But this is really close to our 4-year review. And
Yes.
so we can maybe baby steps, but we will not only be allowed to touch this, but the entire chapter. So,
Yes, ma'am. I'm gonna make
yes.
one other comment. I will not know if somebody is abusing, if somebody is doing the rules wrong or anything to that degree. There will be no complaints because we will never know what is happening in these distance learning programs. It will be all on TDLR
Mhm.
to take care of that situation because we will not know what's going on because we don't have preview to a school and what they're doing. So I'm just saying there will be no complaints filed on our
Mhm.
behalf if I know something's being taken advantage of.
We have a great bit of work ahead of us, and we're ready to do it. Thank you.
Elizabeth, let me ask, when is that 4-year review scheduled?
I don't think we have a firm date for when we're going to send out the notice of hearing. I know that it is imminent. It's coming. We wanted to get past this rule package first. I
Mhm.
don't believe we've settled on a date, but it is going to be after probably the effective date of these rules go into effect.
Okay,
Okay, David, I'd like
yes.
to make a motion to accept the rules as they've been changed.
Do we have
I'll second it,
second
David.
from Carolyn?
Caroline
Guerin,
Guerin, board
please.
member.
Okay, well then, Anna, do we need to take a vote on that?
Yes, sir.
Okay,
Russell Rust,
Yes,
Caroline Guerin,
Yes,
Carol Willis,
Yes.
Antonio Gracia Jr.,
Yes.
Citra Taylor,
Yes.
Callie Moritz,
Yes.
and presiding officer David Lauderstein.
yes,
Motion passes, sir.
good job. And thank you for all your patience and willingness to hear our questions and concerns. Really appreciate it.
Thank you.
Okay, I'm just wondering if we may want to take just a little break before we move into the next part of the meeting. Let me suggest that we take it 10 minutes till 2:40 and adjourn just for 10 minutes. Is that acceptable to everyone?
Yes, sir. Thank you.
Okay,
thank you.
so I'm going to call for a 10-minute adjournment and we'll reconvene at 2:40. Thanks a lot. And thank you all very much for being here. And we're going to begin with the staff reports. So I'd like to call on the licensing division. Jackie Rollins, please go right ahead.
Good afternoon, board members. I am Jacqueline Rollins with the Licensing Division, and I will be giving the report for the massage program for fiscal year 2021. For the massage therapist, the new licenses issued, we've issued 1,648. For renewed licenses, 12,349, and total license population, 25,178. For the massage therapy instructor, new licenses, 175. For renewed licenses, 475. For total license population, 1,388. And for the massage therapy establishment, new licenses, 496. Renewed licenses, 691. And total population, 2,077. That concludes my report, and I'm open to answer any questions.
Sorry, Russell Rust. Do you not have the school, or is that under E&E?
Any?
Okay.
Yes, sir.
She's done, David.
Okay, thank you very much.
Sure. You're welcome, sir.
Let me call then on the customer service division on Dawn Robinson.
Good afternoon, Advisory Board and TDLR staff. My name is Dawn Robinson. I'm one of the managers here in customer service, bringing you the staff reports for the day. Excuse me, my phone. After 20 years of service, first on the roster is after 20 years of service, 15 years with TDLR. Our director, Trey Seals, has left and he has moved on to do other things. We have a new director. He's technically not new. He has been with TDLR for 7 years. His name is Twan Nguyen. He was one of the managers here in customer service. Also, I would like to let the advisory board know that we are excited that we have 7 new customer service representatives. They started on October the 1st. Technically, about the 1st of November, they should start taking calls by themselves. I am very excited. Out of the 7 that we've hired, 2 of those CSRs, of our current CSR, came from some of the divisions here in TDLR already. So it's rare that we have new CSRs comes from another division. Normally, we have them leaving the customer service division, going to different departments, but this time we have 2, one that came from finance and one that came from licensing that's going to join us in our division. So we're excited about that. So the customers will be hearing some new voices starting around the 1st of November. As far as our emails and our licenses as far as our emails and our calls, we had a total of 7,384 emails from September of 2020 to August of 2021, and we had a total of 31,966 calls as well. If you have any questions, I'm here to assist you. Thank you very much.
Any questions? Okay, and thank you very much, Ms. Robinson. I appreciate it.
Thank you.
Okay, now let's hear from Ray Pizarro with the Education and Examination Division.
Good afternoon, Mr. Chairman, members of the board. Ray Pizarro, Director for the Education Examination Division. As you can see, you're looking at the past 2 fiscal years on the providers, massage providers, continuing education providers. This last fiscal year, we've increased with 25 new providers. We have a total of 392. As you can see with the JP exam down below, that JP exam has an increase of 150 or so exams offered. As you can see, that's attributed to, if you look at the FY 2020, you see during the months of April and May, that's the pandemic time or the peak of the pandemic. A lot of that dipped That's probably where we attribute to the decline in FY 2020 versus 2021. If you move down, you will see Russ and massage schools went up from 55 to 62 between the 2 years. Not a significant increase, but there's some new schools out there. Does anybody have any questions about this piece of the report? Russ, were you inquiring something specific about the schools?
No, I was just concerned with the pandemic, I knew we lost like 6 schools last year. I was just curious of how that has affected I noticed we've got more, but that doesn't really say, I know you can't always blame it on the pandemic, but that is a circumstance right now.
Absolutely.
Very
If you
good.
move further down on the report, please, there's about 3,000 plus massage students out there now that we have POMs. We can identify the students who are enrolled in the program. And something new we're doing, and it's new to E&E, it's not new to the department. Customer service has been using Dynamics as a system that tracks very well the kind of work we do, the kind of emails we get, so that they could tackle questions and common questions and type of responses so that we could be more effective when answering questions. E&E had never used this before. We had inboxes out there, and sometimes we get some of the repetitive questions, and we try to find trends so that we can fix the problem and be proactive and not reactive. So we're going to be moving the education examination to this type of email. You'll see when if you email to the education box, you're going to start seeing some automatic responses saying this inbox is not being monitored any longer. Please send your questions through the dynamic system. So all of that is going to be up and running, and we've already started to use it, and it's going to be fully operational, and those old boxes will go away sometime during the holiday season of December. Now to some of the things that I wanted to talk to you about distance learning. If you recall, back on March 31st, 2020, and then again in May 21st, 2020, TDLR enacted some temporary distance education provisions in response to the pandemic. If you recall, when the pandemic hit at its peak, we did not have any resolution and nothing was coming from the governor's office as well on how we're going to kind of supersede some of the already required rules and laws in place to allow schools and students that were affected to be able to finish what they started and try to get a license within the field. So we put these temporary provisions, and remember, the provisions allow the distance learning and virtual learning to be completed for both theory and practical portions of the course. Those are still out there, and those provisions are still on our website. On May 28th of this year, the governor signed the new bill, which is Senate Bill 1130, into law. And you heard Molly talking about the rules earlier today to coincide with this new bill. The bill amended the massage therapy statute. It allows licensed massage therapy schools to offer the curriculum using a new delivery method, and that method is the distance learning piece of it. So that new law allows for at least up to 250 hours to be offered in a distance learning platform for the theory portions of specific subjects, which means that the remaining hours of the 250 must be done hands-on, as a hands-on training under the supervision of a licensed massage instructor. You also heard earlier that you don't have to do this. This is all if a school, a licensed school, intend on offering this alternative method of delivery and want to engage in the distance learning provisions. These new laws and the new rules that Molly has talked about, and it was proposed, and now we're talking about trying to get them adopted, those will go into effect, the adopted rules, effective December 15th. So what we're doing here is we're going to try to get rid of the old provisions that are temporarily out there on the website, and those will go away on December 15th as well. So if the rules is adopted, it's all going to happen simultaneously. The old temporary provisions will be taken off the website. Anyone wanting to teach distance learning as of December 15th and moving forward would have to have those courses, as we've been talking about this throughout this meeting. They will have to be approved by the E&E staff, how you're going to be offering it, all of those things, Russ, that you were bringing up. We're going to want to look at those, and we're going to look at those schools who are approved, and then we're going to turn around and audit all of those schools. So a lot of those schools, whether it's 10, 15, or 20 that becomes approved, we're going to have our auditor within E&E do an audit on all of those online distance learning courses to ensure what they have been approved for, they are doing it in accordance to the laws and rules and continue to do it. Remember, this won't be just a one-time audit. We will be auditing randomly as well. But I want my staff to be proactive to start auditing all of them so we can come back to you during these advisory board meetings and let you know, hey, we got 10 schools who are engaged in the new distance learning rules and laws. And those 10 of them were audited, and here's the common things we found, or the common things we have talked to the schools to fix, or we will tell you there was nothing to fix. They all are doing it in accordance to the laws and rules. So that's kind of where we are right now with those provisions, and I'm hoping, and I think we're all pretty excited, and I think it's going to be a good thing. But I wanted to make it clear to you guys and the public, because there's a lot of rumbling right now on what do I do with distance learning? Can I do this? Can I do that? And I think it's time for us to, this is the right time with Molly presenting those administrative rules to try to get the folks to understand where we're going from this. So you'll see here after this meeting, and I don't mean right after this meeting, but after this meeting, either this week, later this week, you will see the website being updated with new language, letting people know that as of December 15th, if you wish to engage in the distance learning, you will have to get those approved. Now, remember, I want to say it again, the December 15th is a tentative date based on the adoption of the rules. So let's just say those rules don't become adopted, then we're going to probably shift gear on how we approve and get those new distance learning provisions out there. But that's why I'm saying it's tentative. Hopefully it'll all go smooth like normally it does with all of our rule adoptions. And so the December 15th date will uphold. Any questions for me? That's all I have for you guys right now.
Russell Rust.
Sure, Russ.
Yes, sir. And I will say the first E&E meeting, I learned this from you to anticipate what can go wrong. That is what you taught us that first meeting when we started looking at the rules for change and what actually matched the law and what was not matching up with the law. So some of that comes from what you've taught me since we've been at TDLR. I just wanted to mention that. Thank you.
Yes, you will. Carol, I think you probably had a question. I'm not sure. Okay.
Mr. Lauderstein, you're muted, sir.
I just wanted to thank you for explaining that so well. You did a good job.
Welcome.
Mr. Lauderstein, you're muted, sir.
You're muted, David.
All right. Thanks very much. I've been talking and praising everybody to no avail, evidently. So thanks, everybody, particularly Mr. Pizarro, for being so clear. And I believe that Mary Lindsay has some further information for us.
Right. Hello, everyone. I'm Mary Lindsay, and I'm from San Jacinto College in Houston, Texas. And I know that Mr. Rust is right. We really are concerned about some people thinking that this might just be when we have distance education, it's this correspondence course. So we really tried hard at the community college that that we're at to make sure that we don't represent ourselves as a correspondence course. And that's one of our main ideas that we have, that we do work with the students. But I have my little slide up here with my name, and thank you for having us today, and thanks to TDL for inviting us. Just to show a little bit about what we've been doing. We're going to try to hurry through this because I know you've already had a long discussion. And I have Amanda Ross with me, and we just wanted you to know who we were and where we're at. We're in Houston, and we're always willing to help in any way we can with anything that you need, the board needs us. I am not a massage therapist, but Amanda, my full-time faculty is, and she actually is a subject matter expert that has helped put our distance learning courses together. First, I want to start by saying that we are running our courses hybrid, and we do have our hands-on here at the college. So Anna, if you would want to go to the next slide, please, and I'll just try to. We do have this certificate of technology. We have 24 credit hours. We do go over the 500 hours. Our total contact hours are 640 contact hours. We have that with our courses, our 9 courses scheduled through with our Texas Higher Coordinating Board approvals with our 9 courses. Okay. And they are face-to-face hybrid courses. And we have these courses up here for you. Just that's how we run our program, our 24 college credits, 640 contact hours. Okay. Like I said, I'm trying to push this through a little bit. I understood when we started with distance education, and we have been working with this through COVID, and Amanda can talk some more on that. I just don't want to get too in depth. We have our last slide with my email if you have anything you want to email to us. We thought that as we learned about how we were going to gain distance education, we felt like it was with certain courses and specific topics, the legislative, health and hygiene would lend suitable to be distance, pathology and kinesiology. But just remember, those are our lecture portions. We do come to class for our hands-on components. We also felt like business, you can tell I come from cosmetology too, sorry about that slip, that business could be in tune to some online, but we've kept it pretty well face-to-face because of the intenseness that we go over all the rules and regulations with the students. We foresee maybe trying some of that in the future. But with the 250 hours that we would be allotted when we apply for distance education, right now we're just using the 160. And we are designing these courses to be active, collaborative. We do have a learning management tool. It's called Blackboard. And we do have timings that come from Blackboard. We could design that ourselves also, but our timing is coming from Blackboard. These courses are not correspondence. We don't want to be correspondence. The courses are reviewed annually by department chairs, and we try to make sure that student success is a measure that we, our students need to pass our courses. And to pass, we have to produce a transcript where they've passed the course for their 500 hours to sit for their boards. But of course, like I said, ours is 640. Instructors have to go to training to be able to put these hybrid formats together. And we work hard on making sure we have collaborative sessions where we actually are like we are today, and our students come to class, and yes, then we will take a role as they are there, class roster certification. And then we also go into assignments that they must turn in at a specific time. We have a calendar that is timed. If they have something due, if it doesn't come in, then they receive a 0 on that. So we are trying to capture a live audience as much as we can online. Okay, Anna? I'll turn it over a little bit to Amanda now. So like I said, she is a subject matter expert. I'm here for you also to answer any questions that I can answer.
Russell Rust, I have one question, but as a college, y'all are exempt from having a license as a massage school in Texas. Therefore, y'all are able to do pretty much however you want to do the program as long as y'all can show a transcript for the students to be able to be applicable to a state license, correct?
Yes, that is correct, but we follow all of TDLR's guidance when we're putting together our curriculum.
Oh, I understand, but you're not required to, so,
Yeah.
all right, thank you.
As a community college, you are correct. So, as Mary mentioned, again, I'm Amanda Ross. I'm the full-time faculty here, therapy department of San Jacinto College. Our learning management system is Blackboard, as Mary mentioned. It is a user-friendly format for consistency and understanding. We recognized when we had to put our courses on abruptly online during COVID, the first kind of move to put everything online for students. We realized that if the courses weren't formatted consistently and very student-centered, that students were going to have difficulty understanding the material and finding what they needed. As Mary mentioned, we have to take a course about on how to be an effective online instructor. That's a SANJAC rule. It goes across the college. It's not just for massage therapy. And so all of our instructors that summer of 2020 took the training in order to qualify to teach online courses or distance learning courses for SANJAC. In this course, we learn how to put together modules that are completed weekly, and we keep them active, as it says in the second bullet point, using discussion boards, collaborative online sessions, and group projects. We want our learning to be engaging and, of course, centered around student success. Last, on student attendance, I know that Mr. Russ was asking quite a bit about this subject matter. We monitor it through Blackboard. It's an integrated software program called Quickly Attendance. So anytime an instructor logs on at SANJAC College now, be it massage or elsewhere, we are able to see the last time a student logged on. We are able to see their activity that has taken place, and we're able to monitor it. Anytime students miss time in class, they must make it up with a licensed massage instructor. What else was I going to say?
Anna, you wanna?
Russell Rust, I have one more comment. This looks very interesting, and I would hope maybe TDLR will learn from this system because this looks like it is very interactive with the student, and y'all have set in some parameters so maybe this can be used by TDLR as a guide for all the other schools that are going to use TDLR. I appreciate y'all being here and pointing out all the things y'all have in place for this to be something that is actually oversight on y'all's part. But thank you very much for that.
Russell, Ray Pizarro, Director Education. Sorry to interrupt, but this is one of the reasons why we've asked San Jacinto and Mary to attend this. Mary is one of our board members, current board members for cosmetology, and I knew that they have these programs here. As you heard in one of your questions, Russ, saying that they're an exempt school, but you heard Mary talk about that they are responsible to the higher education board. So a lot of these colleges who are offering these courses, they got to be vetted through the higher education board. They're not just teaching it to teach it. They got to be vetted, and they got to be accountable to whatever learning management system they are doing at that school. So this is their Blackboard learning management being monitored, if you will, by the higher education board to ensure that the students are engaged in this distance learning or actually completing the course in accordance to TDLR's requirements. So it goes hand in hand, which is why they're exempt, because they're already being responsible to the higher education board. Okay. I wanted to throw that in because I know you heard some of that.
Yes, Ray, and I appreciate that. The standards they have to live by are so much higher than when we have to as a licensed massage school. I have never, I understand what they have to go to and what their standards are, which is totally exempt from what we do as having to have a massage therapy or school license in Texas. Like I said, the standards they have to in play, I mean, there is no comparison, and I completely understand that, okay?
Okay, thank you.
Anna, if you just want to show that last slide, we'll skip on for value of time. I just want y'all to have my email. If you ever wanted to contact me, I'm more than willing to support and help you through implementing distance learning for massage. And yes, you're right. We try really hard to make sure that we are educating massage therapists that will lend well to industry. And so we appreciate it. Anything we can do to help you. Amanda is like I said, my subject matter. She'll help me if I don't know, Amanda will.
Amanda, Mary Lindsay, thank you so much for stepping in and doing this. Brian Francis, our executive director, wanted us to bring some of this this point of view from a college, so that we all can look at these things, especially with the new provisions coming out there, so that Russ, so that when we do meet in a work group, to David's point, we have some ammunition to use. There's some things maybe we can learn from all of this and improve whatever the process we need to improve. So this is just something I wanted to make sure it's out there that we all can just have a look at.
Absolutely. Thank you.
You guys.
Thanks for having us today.
Thank you, Mary. Good luck with all that you all are doing. Congratulations.
Thank you.
Okay, let's move on to the Enforcement Division, namely to Rebecca Burkhalter, please.
Hello, everybody. This is Rebecca Burkhalter from the Enforcement Division. You guys can hear me, right?
Yes.
Okay, good. Just checking. Okay, so first of all, I have some personnel updates for you. On August 1st, 2021, we hired a new Attorney 3. Her name is Cynthia Marple, who is a member of the Transportation Team. Welcome to the Enforcement Division, Cynthia. We also have 2 notable promotions to mention as well that occurred mid-September. Kim Ferrero Mitchell was promoted to Management Analyst 3, having been with our agency for 13.5 years. And Estella Ramos was promoted to Senior Legal Assistant in our Intake Division, having been with our agency for 6 years. So congratulations, ladies. Next, statistics. In our July meeting, we were looking at statistics that were for the first 3 quarters of 2021. We now have the final numbers for fiscal year 2021 now that we're past September. You'll see the massage program continues to take up a large portion of enforcement's total caseload. Of note, in the first set of statistics, the higher number of cases in massage that result in disciplinary action versus the TDLR average. 24.17% of cases resulted in disciplinary action in massage versus our TDLR programs where only 13.41% resulted in a disciplinary action. I think this reflects that the cases that were filed with our division were not only meritless complaints, that there were some enforcement actions that were required in your industry. If you look at the next page with the case outcomes for fiscal year 2021, you will see our enforcement division has been very busy with the massage program, assessing and collecting a large number of penalties. However, I also always want to highlight that our goal in enforcement is compliance. And therefore, you see that 649 cases were closed as informally resolved because the respondent corrected the behavior, obtained a license, or otherwise cured the violation in some manner. Remember, the next graphic of alleged violations at opening is only what was alleged when the case was originally opened with TDLR. Anna knows this already, but I prefer to focus on the next one, where is the top violations that actually resulted in a disciplinary action. So you can see we're still seeing a lot of unlicensed individuals practicing massage therapy, but there are also a lot of consultation document violations found. The next batch of statistics are for fiscal year 2020 overall. These were actually included in the July meeting materials, so I don't want to go over them again, but you can actually compare fiscal year 2021 to fiscal year 2020's numbers with these two reports, and you'll see the numbers are fairly consistent between the two fiscal years as far as the enforcement division's work on this program. So if we don't have any questions about the statistics, I'm going to go on to cases. All right, the first is John Schmidt. This case was handled by my fellow prosecutor, Victoria Meza, in which she obtained the respondent's agreement to remove himself from the massage industry for his lifetime. Our team refers to these as lifetime bans, and they are the result of an agreement with respondent. We believe these are in the best interest of the profession when we encounter a certain set of facts where it appears the respondent is not suitable for the massage therapy profession. This case by my fellow prosecutor Victoria is our team's most recent lifetime ban. The next case is Mary Good. This is a criminal history case that was handled by one of our criminal history team prosecutors, Trevor Thielen. The respondent was recently convicted of a prostitution offense, which made her ineligible for the massage therapist license. The next case is Perfecta Massage. This one was handled by another fellow prosecutor called Morgan Cumming. This is an agreed order where Perfecta Massage accepted liability for 3 counts of employing unlicensed massage therapists, allowing an employee to practice massage in clothing designed to arouse, and failure to provide a consultation document to the client. Respondents have paid a $7,750 penalty and agreed in the agreed order to cease and desist from hiring unlicensed massage therapists. Side note, this is not an official cease and desist order. It is just an additional agreement that the respondent made, and enforcement prosecutors are hoping perhaps we can use that in a subsequent violation. So that's why we like to add that. The next case is Sedona Massage. This is one of my cases. On this case, the respondent agreed. She had a consultation document that lacked required items, that she had employed an unlicensed massage therapist, and she had allowed an employee to reside on site. She paid the penalty of $6,750. All right, the last case is Sunny Health Spa. This is another one of Victoria's cases, and I wanted to highlight this case before the Massage Advisory Board to show how our agency is working with local law enforcement when we have difficult cases. This case is the result of a default order as the respondent failed to answer the notice of alleged violation. They were fined $21,000 for a list of violations, and the massage establishment license was revoked. The case was the result of a coordinated effort between the Houston Police Department's Differential Response Unit, the Houston Police Department's Vice Unit, and our own department's enforcement investigators. And then I also wanted to point out that after the default order was signed, the City of Houston was successful in securing an agreed final judgment and a permanent injunction against the owner, Yu Hui Lee, which found that respondent's operation of Sunny Health Spa was a nuisance under Chapter 125 of the Texas Civil Practices and Remedies Code. So I'm available if you guys have any questions.
Russell Rust, I was just curious. I always notice that Houston participates with you. Does the Dallas area not do the same thing as much, or is that not relevant? I was just curious. I always notice the Houston police force or action, but I never see Dallas mentioned in any of those.
So Board Member Rust, I want to remind you that we select a handful of cases to sort of demonstrate enforcement activities. So this is absolutely not exhaustive.
Okay.
We do also work with Dallas and other police agencies around the state. This is just highlighting how well this one in particular worked out.
Sergeant Tony Gracia, that question. Yeah, my Vice Division, General Enforcement Squad, Human Trafficking Unit, as well as a division, West Side Division's DRT, assisted with that investigation along with city legal. So it's a collaborative effort to close that place down. It's been open for many years.
Thank you very much. Appreciate it. Okay.
And as a final closing note, Board Member Gracia, that's exactly why I like to highlight these types of cases is, in my opinion, regulation of massage is a joint effort, and TDLR cannot do it completely alone, not when there's illicit things going on in the industry. And so I like to highlight when our collaborative efforts were successful.
Also, too, I'd like to highlight that we work hand in hand with TDLR's human trafficking unit. They come down. Actually, they're down here this week.
Okay, that's very good to hear. Thank you so much.
Thank you.
Okay. Let's move on to the Regulatory Program Management Division. I'd like to call on Mr. Jerry Gonzalez, please.
Good afternoon, Mr. Chairman and board members. My name is Jerry Gonzalez, and I'm with the Regulatory Program Management Division, and I'm here to present your report this afternoon. Currently, the RPM staff is involved and still helping on various teams to implement the new bills that passed this last legislative session. We also continue to assist the enforcement, field inspections, licensing, examination and education division, customer service during investigations, inspections, or any routine calls or questions that they may receive. As a reminder, also, we posted on our massage website a sample consultation document that was updated in the summer in June of 2021. That is still up there if anyone wants to compare that to what they're currently using to be sure that you're still in compliance with what the rules require. As Rebecca mentioned in her report, there are several issues with the consultation document. So it'd be a good review to the sample that's out there and compare it to the ongoing list. As far as our outreach programs, I recently attended the Federation of State Massage Therapy Boards annual meeting that was conducted virtually on October the 8th, a couple weeks ago. Also, we have the latest edition of the TDLR Health Monitor that came out in August. Those of you that are interested in receiving information about our program, updates with the newsletter or changes like these proposed rules, please go to our website and sign up for notifications, and you'll get updates on changes to the program or any new information that may affect your program. The good thing with signing up for these notifications is that you can choose what programs you want to receive information on, whether it's all of TDLR, only massage therapy, some of our other programs. Say you have, like Mr. Benny earlier, athletic trainer and massage therapy therapist information. So that's always a good site to keep ahead and informed of what's going on with our programs. And finally, again, if you have any outreach events or meetings, conferences, something that TDLR can be a presence in, please let me know. We'll make every effort to attend any function that you may have. And that concludes my report, unless you have questions that I can assist you with.
Russell Rust.
Yes, sir.
Jerry, I'm really confused about Senate Bill 1831 and how to analyze what is going on and how that applies to the massage industry, because it looks like things were just added in to the bill that I'm just not, I mean, all entrances of premises have to have a sign, at least every 500 feet an exterior door. Every entrance into a parking lot. I'm trying to see what applies to us, what applies to state parks, what applies. So is there going to be any clarification on that bill?
I'll have to look into it and see what and how it's addressed, because as you mentioned, sometimes some of these bills affect a big old compass of people and agencies and programs. And some of the things like I'm trying to blank on the health professions bill that related to patients, but they included massage therapy into that. We don't deal with patients. So it really didn't affect us in that manner. So I'll need to go back and check on that. And what was the bill number again, sir?
It is, oh, I'm sorry, hold on just a sec. Dadgummit.
Yeah, I said
Hold on just a second. I'm sorry. For some reason, I closed it about. Senate Bill 1831. And
31. Okay, yeah.
that, it specifically says massage therapists, tattoo studios.
Yeah.
But if you go and read the context of the whole bill, you know, community colleges, I mean, that just trying to get a direct application for the massage industry, massage schools, clinics. It's a little open-ended that I'm just not quite understanding what
Okay.
directly applies to us.
Definitely. I'll take a look at that. My link to our internet where I'm looking at most of the bills just went on the blink. So let me take a look at that and I'll get back to you and see how it affects us. And then depending what it affects, we can put a general statement out on our webpage as well to see who it really affects and what needs to be done in reference to that.
Okay,
Senate
no
bill.
problem. We already display the human trafficking signs.
Yeah,
like
yeah,
we're
that one's
supposed
on
to.
there.
But-
And there's some really, like the new portion of it, it's basically adding the information for contacting with DPS information on there in the new one, they said, but I need to see what the final version with that we came across and see what we decided on, because I know we were working on updating those signs as well to include that information.
Okay, thank you, sir.
Yes, sir.
Yeah, I agree. There's some things that clearly could not apply possibly to massage therapy. So
Exactly,
thanks
yes,
very much.
sir. And I'll take a more detailed look at that, Bill.
Great. Thanks so much, Mr.
You
Gonzalez.
bet, thank you.
And thank you for your report. Okay, let us move on to the Field Inspections Division, Cam Tran. Thank you very much.
Good afternoon, Mr. Chairman, Advisory Board members, and TUR staff. My name is Kem Tran, East Region Manager. I will be presenting the field inspections report today. I will start with the personnel updates. Liaison James Turner resigned effective August 18, 2021. And we have Central Region Inspector Delinda Chu have accepted a promotion as a liaison effective September 1st, 2021. And next is statistics inspections. Massage establishment. As you can see that fiscal year 21, we inspected only 361 inspections due to TIRA suspend inspection on March 17, 2021 in response to the COVID-19. The date on here will need to be corrected. We suspend the inspection from March 17, 2020 to May 19, 2021. So it's more than a year. And massage school inspection, we only completed 19 inspections for the same reason that the inspection was suspended more than a year from March 17 to May 19, 2021. And our most common violation found during the inspections is same thing as the last report. The first 5 items are the one that we see most, is involving with the establishment did not maintain employee or independent contractor list, or they don't have it available during the inspections. And the massage therapies individual failed to attach the current photo to the license. And it's also did not display to the public. And the establishment did not have human trafficking sign post to the public review. And the business did not provide complaint information to the clients, such as they're supposed to provide TDR name, address, phone, or email website address. By posting the sign at the location, or they can print it on the receipt, or they can show it to the clients. So mostly they did not do none of those. So those are 5 items that we still see most, and the rest of them still the same as the last report. For the school, we don't have it. We don't have the 4th quarter as of this moment. Our current project on August 3rd to the 6th, the field inspection in a joint effort with anti-trafficking unit, ATU team, and local law enforcement participated in successful inspection blitz of massage therapies establishment in Corpus Christi. 11 field inspection staff was completing 22 inspections and 6 confirmed closures. And on September 9, Central Manager Juan Munoz was reviewing massage therapy school inspection reflection with all the massage inspectors and the managers. And as of September 29, all 5 inspectors that were trained in the past year completing the training. So we are now have a total of 10 massage establishment inspectors. Regarding to COVID response, from the last item, I'm gonna read the last item because the rest of them we already reported from the last time. So as of August 31st, we completed 3 virtual establishment inspection and 3 virtual massage therapy school. Last Friday, which is this item is not in this report. Last Friday, October 15, the field inspections assisting the licensing department with fingerprint phone call. What it is, we have a whole list of the establishment that did not provide the fingerprint to TDR. So we call them and check to see if the location is closed or if they forgot to do so. So that was the last item I have in the report, and I'm happy to answer any questions.
Okay, any questions?
Yes, Russ, one thing. Thank y'all for the efforts. Have we been able to see on violations on the website of any of the enforcement or what transpired in Corpus yet, or are those still pending, those cases?
So as of this moment, I'm not sure if I have the current update, but we already turned in our report to enforcement, and I believe enforcement really have full hand on that, but they are working on it.
Yes. Okay. So it hadn't been reflective yet. Thank you.
Yes, sir.
Well, thank you very much. I appreciate it.
Thank you.
Okay. And then the last item of staff reports is the executive office. I call on Christina Kaiser, please.
Good afternoon, Mr. Chairman and board members. I am Christina Kaiser. I'm one of the deputy executive directors here at TDLR. My area of responsibility is regulatory services, and so I'm responsible for the enforcement division, field inspections, and the regulatory program management group. Thank you all for being here today, and I wanted to tell you how much I appreciate your attention and feedback during the review of the rule package that you reviewed earlier today. For my staff report, one of the items we've been asked to cover is the legislative session. And since you just met a few months ago, I'm going to try not to be redundant of things that we reported in July. Of course, the legislature met in regular session from January to June 1st of this year. During that session, TDLR was monitoring about 300 bills that related to TDLR in some way. Out of those, about 50 of them passed. One of the big bills that was related to TDLR was House Bill 1560, TDLR's sunset bill. Thankfully, that did pass on the very last day that the legislature could pass bills. And so TDLR was continued for 12 more years. One of the things, and Mary kind of foreshadowed this a little bit earlier, one of the things that the sunset bill did relating, or there are a couple of things actually that it did relating to advisory boards. the Sunset Bill removed from statute, from the individual program statutes, all the provisions that established specific intervals at which advisory boards are supposed to meet, and instead added language to our enabling statute that just simply stated advisory board meetings will be held at the call of the chairman, or excuse me, the call of the executive director of TDLR. And so I'm not sure, frankly, if your statute did have one of those provisions in it, but if it did, it has now been removed. Another thing is that TDLR's advisory boards are authorized now to continue holding fully video conference meetings. And y'all talked about that a little bit earlier. That is even, after the governor's executive orders related to the COVID pandemic expired. And so that is something that we can continue doing with advisory boards on an ongoing basis. And finally, the Sunset Bill authorizes TDLR to create interdisciplinary advisory boards to work together on common issues. And so one of the board members earlier commented about, a potential crossover between the massage industry and the barber or cosmetology industry on some issues. In a situation like that, if TDLR has an issue that needs to be explored with representatives of multiple professions, we now have this opportunity to create the interdisciplinary group rather than having one or having 2 or 3 or 4 separate advisory board meetings and having a disjointed conversation with separate groups. So with the end of the session, we are now about the business of engaging in bill implementation, implementing all of those various bills that passed during the legislative session. And actually the rules that were in front of you today were the product of 2 of the bill implementation teams. Bill team number 7, which is headed by Miss Mary Winston, was responsible for House Bill 1540. And then bill team number 8, headed by Ray Pizarro, was responsible for Senate Bill 1130. Both the changes related to both of those bills were featured in the rules that you looked at today. I wanted to also just mention, since Miss Winston is in the room, and to thoroughly embarrass her, Mary is also responsible for bill team number 3. And this is a team that has a whole lot of work that they've already done and are continuing to do relating to advisory boards. Her team is responsible for implementing those provisions that I talked about earlier related to advisory boards that are in the Sunset Bill. She is also responsible for winding down some advisory boards that are not going to exist any further, like, for example, the Polygraph Advisory Board. Polygraph examiners were deregulated in the Sunset Bill, meaning they no longer have to hold a license from the state of Texas in order to practice as polygraph examiners. And so that advisory board had to be wound down and ended. Similarly, there are some changes in composition to some of the other advisory boards. And so her group is busy with lots of stuff relating to advisory boards. And I just wanted to sort of recognize that she has a lot going on, and she's been doing a great job with that. That concludes everything. Oh, one other item I wanted to mention. On the agency's website, since you last met, there is a little bit of a different look to the search where you can pull up the bills that passed during the last legislative session. Anna, I don't know if you have the website in front of you, if you could easily pull that up. In the middle here with the picture of the gavel, if you click on that, there is now it's a press release that was issued at the end of August, basically announcing to the world, these are all the bills that passed this legislative session that relate to TDLR. If you scroll down through this document, there are still links that you can go to that will take you directly to the bill on the Texas Legislature online website. So you still have that functionality here. But I just wanted to mention, if you haven't looked here in a while, all the information is still there. It's just laid out a little bit differently. That concludes everything I wanted to mention about bill implementation and the legislative session. If there are no questions for me, I would like to yield the floor to Mary Winston for the final part of the executive staff report.
Okay, thank you very much.
Thank you so much, Christina. That made me blush for real. So
Oh.
I appreciate that. We just want to wrap up this section with a couple of these statistics. And this is some high numbers, but this is good. This website for massage therapy has been visited almost 200,000 times in the past 6 months. 42% of the visitors do so from desktop computers, 56% from a smartphone, and we still have those couple of percent that actually use that tablet. Reasons for coming to this site: how do I renew my license? Fingerprinting instructions for current licensees, and massage therapy examination requirements. Wrapping that up, for that top 5 are administrative rules and frequently asked questions. This gives us a snapshot on what folks, licensees, members of the public, are seeking information on, and it helps us to develop what our website should look like. Our webmaster, Mr. Michael Fickle, as well as the rest of his team, compiles this list and makes sure our website is user-friendly and up-to-date as much as possible, so we can be of assistance to our licensees and the public. And that wraps up this section.
Excellent. Thank you, Mary Winston. And thank you, Christina Kaiser. I appreciate it. So we are now approaching the end of the meeting. I just want to check in with anybody with TDLR or the board members. Any final comments that you feel like you need to make before we discuss possible agenda items is one of the topics we could take up. Anybody have any comments at this time? Callie Morris.
Just had to unmute myself. I'm new, obviously, so that being said, there were things that I was trying to work on prior to coming onto this board, and I'm hoping that I can get some assistance. I'd love, like all of these people here, to get more people into massage therapy. And I was aware that the chairman of TDLR had worked with TWC to get grant money for the electrician program, and I'm going to try to do what I can, but of course would look for any kind of help or guidance to try to get grant money for massage therapy and being recognized as a viable option for a career, so that we can get more people into these programs. So that was one of the things that, I would love to see if there's any way in getting assistance through TDLR to make that happen.
That's a good question. So just any comments?
Ms. Morris, Mary Winston here. We will chat offline and we will kind of further discuss, and because we weren't involved, so we're not sure how we can do that, but we would love to discuss options with you. We know that some of our licensees, even if we have a large licensee body, we get numbers of the average age, so forth and so on. And so we want success. So we will definitely reach out to you. Thank you.
Thank you.
Good. Okay.
Excuse me, David.
Yes.
Jerry Gonzalez, I just wanted to reach out to Russell and yourself. Thank goodness my internet came back up. But in reading the portion that you were talking about, where it talks about the 500 feet and long parallel walls, exterior, that's referring primarily to the education code and for schools and health and safety code, not to the massage program. For us, in the section that's below that is the portion that talks about the human trafficking signs that we already have posted in our facilities already. But I'll do some more digging, but I just wanted to initially give you more or less what I found so far in that to ease your mind on that, where we need to post those.
All right, thank you, Jerry, but it specifically said massage schools and educational programs, so that's why I thought it threw something additional in for us, but
Now,
thank you.
it's further down in item C, not at the beginning of it, and it refers at that point, but it doesn't require at that in those sections about posting every 500 yards or
Mhm.
parallel or exit signs and things like that.
Okay, thank you, sir.
Yes, sir.
Good. All right. Well, we've had a nice long meeting, very thorough. And is there any discussion needed about next time, date for the next meeting, or shall we table that for further correspondence? Let me ask
Mr.
Anna.
Lauterstein, Mary Winston, we
Mary?
can, Anna will definitely poll the board and get some dates for you. We have had a wonderful and long meeting, but it was very insightful and informational. So yes, she will reach out afterwards.
I
Okay,
thought
that
Mr.
sounds good.
Francis had to tell us when we could meet again.
Well, as his proxies and the chairman of the commissioners proxy, we will let you know.
Russell Russ would like to be recognized.
Yes, sir.
Go ahead.
I'd like to make a motion to adjourn this meeting.
Caroline Guerin, I'll second that.
Okay, thank you all very much for your patience and your participation, board members, TDLR people. Again, thank you so much, really appreciate it. I will now adjourn the meeting. It's 3:42. Thank you all again.